Let's talk about something that's a reality for any economy. What happens when a business, or even an individual, gets into serious financial trouble? In Singapore, there's a whole set of laws for this, and at its core, it's all about managing a tough situation in a way that's fair to everyone involved. We're going to break it all down.
Right, so this is the question, isn't it? Imagine a company. The suppliers are calling, the bank is on the phone, payroll is due next week, and the money just isn't there. This is exactly when the law has to step in, not just to collect debts, but to manage a really complex situation with huge stakes for, employees, the owners, and even the wider economy.
So what's Singapore's game plan here? Well, it's actually less about punishment and way more about being pragmatic. The whole system is really built on a core idea about what it takes for a modern economy to thrive, even when some businesses, inevitably, don't make it.
At its heart, Singapore's legal framework basically accepts a simple truth. If you want a culture of risk-takers and entrepreneurs, some businesses are going to fail. That's just part of the deal. So instead of penalizing that failure, the law tries to manage it fairly. It's all about striking a balance between trying to save a struggling company and protecting the rights of the people it owes money to.
And this brings us to this really critical moment. A fork in the road, you could say. When a company is in deep trouble, it faces two fundamentally different paths. On one side, you've got corporate rescue, all the tools designed to save a business that's actually still viable. And on the other side, winding up. That's the end of the line, where the company is dissolved in a structured, orderly way. So, first, let's go down that rescue path. This route is really for companies that are, at their core, pretty solid, but just need some breathing room to get back on their feet and survive.
One of the main tools for a rescue mission is something called judicial management. The best way to think about it is like putting the company into a financial ICU. The court steps in and appoints an independent specialist, the judicial manager, who actually takes over from the existing directors. This creates a legal bubble around the company, a pause button called a moratorium, which shields it from lawsuits. It gives the manager time to figure out what's wrong and try to engineer a turnaround.
Now, this whole process isn't just about kicking the can down the road. It has very clear goals. You can think of it like a plan A, B, and C. Plan A, the absolute best-case scenario, is survival, getting the company back up and running. If that's not going to happen, we move to Plan B, negotiate a fair compromise with the creditors. And if all else fails, Plan C is to at least sell the company's assets in an organized way so everyone gets a better return than they would in some chaotic fire sale.
But what about that other path at the fork in the road? Sometimes a rescue just isn't in the cards. And in that case, the process shifts completely from trying to fix the company to, well, dissolving it.
This is what we call winding up, or liquidation. It's basically the final, orderly shutdown. A liquidator gets appointed to gather up everything the company owns, sell it all off, and use that money to pay back as many of the debts as possible. You could almost think of it like an organ donation for a business. Its valuable assets are passed on to those it owes before the company itself officially ceases to exist.
Okay, and this is one of the most critical parts of the whole process, the pecking order for who gets paid. Not everyone is equal here. Right at the top of the list are secured creditors. Think a bank that has a mortgage on the company's building. They get first dibs on specific assets. Next up are what's called preferred debts, and this is super important because it includes things like employee wages. After they're paid, you have all the unsecured creditors. They all share whatever's left based on a principle called pari passu, which is just a fancy way of saying everyone in that group gets paid proportionally. And then dead last, if by some miracle there's anything left over, it goes to the shareholders.
So far, we've been talking about companies, but of course, financial trouble can be deeply, deeply personal. So let's switch gears and look at what happens when an individual just can't pay their debts.
This number right here is the magic number in Singapore. It's the key threshold. A creditor can't even start the bankruptcy process against someone unless the debt is at least 15,000 Singapore dollars. This makes sure that this pretty serious process is reserved for significant amounts of debt.
And once a bankruptcy order is actually made, the effects are immediate and they are big. An administrator, called the official assignee, takes control of pretty much all of the person's property. Major restrictions kick in. You can't just leave the country without permission, and you can't be a company director. But it's not all negative. Just like with a company, a legal shield, that moratorium, goes up, protecting the individual from getting hit with more lawsuits from most of their creditors.
But here's what's really crucial about Singapore's modern approach. Bankruptcy isn't seen as a life sentence. It's a path to getting back on your feet. There is a clear light at the end of the tunnel. A first-time bankrupt who cooperates can actually be discharged, meaning freed from bankruptcy, in as little as 5 to 7 years. That creates a really powerful incentive to work with the system and earn a true fresh start.
So when you put it all together, the corporate rescue missions, the orderly shutdowns, the framework for personal bankruptcy, you start to see this clear, overarching philosophy at work.
The entire system is really guided by these 4 big ideas. It's designed to be progressive, so it can adapt to a modern economy. It needs to be effective. It has to actually work. It has to be fair to everyone involved. And it's got to be efficient, so these processes don't just drag on forever. It really is a constant, delicate balancing act.
And that really leaves us with this final massive question. It's the central tension that every single insolvency system in the world is trying to solve. On one hand, you absolutely have to protect the people who are owed money. But on the other hand, you want to encourage people to take risks and start businesses, and that means allowing for the possibility of failure and a second chance. Finding that perfect balance? Well, that's the never-ending goal.